points, some MLC points, and then some comparative study between the old and, because we have left halfway yesterday, so we'll try to complete that, and then what exactly illustrate the most of the changes that have happened in the Indian Evidence Act is that in the illustrations especially, not much change in the content and the text of the section, but then if you see most of the illustrations that they are citing, that they are quoting, so where the old fashioned words like vakil, isn't it, vakil, attorney, these words were little old, so nobody now, though there are movies which have come with the name, vakil and all, but then they were old fashioned little, so they try to replace that word vakil and attorney with advocate, because advocate we are all familiar with, so they are replacing that word, substituting that with the advocate word. So that is the one thing, and major thing in the initial chapters only, that is the sections, starting from 1 to 3 and all up to 4, 5, they have given up to 4, they have been mentioned as a separate sections, So, but then here, as we all know, the definition sections, as we are all familiar, it will invariably be put in section 2, so that it becomes very easy for all of us. Section 2 माने वो तो definition का section है, वैसा. So like that they try to put these things, shall presume, may presume, conclusive wali, then all that they try to put under section, and then they are giving a subsection like 2 within brackets 1, and इसका भी subsection clause जो है 1 बोल के ऐसा they are giving that. So that is one difference. And in old Indian Evidence Act section 8 जो है, so which is talking about the motive, preparation, previous, subsequent conduct and all, so they are mentioning, so wherever the figure 10,000 is appearing, that is also again in the example, so where 10,000 figure is appearing, they are putting it in words, that is TEN 10,000 jaisa, so written in words and all, 10,000 bolke, they are showing that as they are given it as a figure, but then they are writing it in words, 10,000 bolke, wherever that number is there, they are writing that. And one more thing, in illustration J, they have used the word, the question is whether A was ravished bolke likha hai. So ravished, in place of ravished word, they are using the word raped. So ravish word, they are replacing it with rape. And similarly, other states, earlier we used to call them Calcutta and all, Mumbai and all, Bombay. So wherever now there is a change in name. And for example, Kabul is the word, for one state they have used Kabul. And in Kabul they have replaced that with Singapore. So this we have already discussed yesterday. And then when it comes to section 14, now section 14 is talking about, in the old version of Indian Evidence Act, it says, the heading says, facts showing existence of state of mind or of body or bodily feeling. This is the heading of section 14 in the Evidence Act, and now in that place it becomes now in the new act as 12. Now, so coins, as I told you, coin is now replaced by currency. So coins as such, they are not coming in the offense category anymore, because as we have discussed earlier, for anybody to make a fake coin and the technology that he has to use will be much more, and the investment that he has to keep on that is much more. So instead of preparing or manufacturing, counterfeiting a coin, it is worthwhile that he should go for some high denomination of a currency, then profits are more in that transaction. So that's the reason why now fake coins and all, the concept has gone. So that is the reason probably where whenever coin a word is appearing, they are replacing it with the currency. That also we have to and these illustrations only, they are more keen to change and all, that is what is given in that section. And other sections like similarly in section 21 also, same illustration only, you see that wherever coin is there is replaced again by currency, and Kolkata, these names are also replaced. Now you see that when it comes to 22 and 22A, they have given in the old Evidence Act, there is again this 22 capital A, because A capital B always indicate amendments. So earlier there were amendments and they have used these capital letters. Now what they are doing in the new act is they are going to club, removed one section, and then they are going to club it 22 and 22A, and they have put it in section 20. That is, what is that? When oral admissions as to contents of the document are relevant, and when oral admissions as to contents of the electronic documents are relevant. So these two, what they are trying to do is they are removing one and then they are clubbing these two and then putting that in 20 section in the new thing. And as I said yesterday also, in section 24 now, which has become 22 in the new act, confession caused by inducement and all, we have discussed this earlier also, yesterday also. They are using the word, because every time whenever we use inducement, threat, promise, we also use the word coercion. This you must have observed in Contract Act also. They are using this word coercion, misconception, coercion. These words, they go in tandem. So probably the legislators must have felt that since these words go in tandem, so since they find that this particular coercion word is missing in the old version of Evidence Act, they are trying to put that again, and that has been added. Now another thing is, they also try to 25 and 26. Now both these sections are clubbed, and then they have made it as 23 in the new version with the subclasses 23(1) and 23(2) subclasses. So what are these things? They also talk about confession, and 25 says in the old version, confession to police officer not to be proved, and then the other one is confession by accused while in custody of police not to be proved against him. So both these, since both the confessions relate to only policeman, one need not be proved, again another one says while he is in the custody. So almost both of them are sounding very near. So what they said is, instead of putting it as a separate section, they have put it as in the new section, new act, as 23, and they are giving subclasses. 23(1) is for confession to police not to be proved, and 23 subclass 2 they made it as under custody. So that is how they have adjusted these two, clubbed and then adjusted that way. And again coming to section 30. Section 30 also there is a little modification, some addition has taken place. So turning it to 30, there is only one explanation. If you see the Bail Act, old version of Evidence Act, you see that the heading reads as consideration of proved confession affecting person making it and others jointly under trial for same offence. So under that particular heading, they have given explanation. Only one explanation they have given. So what is the explanation? Offence as used in this section include the abetment or attempt to commit the offence. So normally abetment and attempt, they are separate things, because even for some offences, even abetment, attempt or preparation, some offences, they are also they are also treated as punishable, isn't it? Now here in this explanation they say offence also includes abetment or attempt to commit that particular offence. So in addition to that explanation what they have given for the understanding of offence, they also added one more explanation in the form of explanation 2. What does that explanation 2 say? A trial of more persons than one held in the absence of the accused who has absconded or who fails to comply with the proclamation issued under section 82 of Bharatiya Nagarik Suraksha Sanhita 2023 shall be deemed to be joint trial for the purpose of this section. So in order to understand what a joint trial means, they have expanded the explanation of joint trial. The word joint trial has been given a little elaborate explanation, and then they have added that as explanation 2. Earlier, if you see the old version, you find only one explanation. So there is an addition now in the new act in the form of an explanation 2, and explanation 2 is added here. So it is talking about the joint trial of if more than one accused is there, and suppose the accused is absent, or if he is absconded, then or who he fails to comply with the proclamation. Proclamation means when the person on whom the summon is to be served, if he is not found in spite of the best efforts made by the officer who tried to serve the summons, then as a resort they can also declare him as a proclaimed offender, and then they can do that. So if a person is under the proclamation, then such a person also deemed to, against whom also we have to presume that it is a deemed class rather, shall be deemed to be a joint trial. If suppose that person is no more, he is not visible, he is absconding, isn't it, and he is absent, and against whom also there is a proclamation order. So if such a situation arises, even in case of a person who is a proclaimed offender, against him also if there is if he is not available, the joint trial can also be done to him. So that's what is the explanation 2, which is given under the section 30 of old version, and now it becomes 24. Then if you see now again the expert evidence is coming under which section? Old version? You should all tell me.
45.
Now if you see the old version of 45, it says the heading is opinion of third person when relevant, isn't it? So they have included 45 under 45 opinions of experts. What are all the areas they have mentioned? One is foreign law, science, art, like that they have mentioned, handwriting, fingerprints and all. So they also now are adding, or any other field, that is the word they are now adding. Only addition in that is little wording. What does it say? They have mentioned all others, but then any other field tomorrow, like electronic evidence, tomorrow something else may come, isn't it? So to incorporate, to make that definition little wider, scope of the expert opinion, they are also including a word called any other field. So this is also important. You may have to note, make a note of that. Then as I said, opinions as to handwriting when relevant, the 47th section. So 47 and 47A, there was an amendment earlier. Now they have removed this amendment. They have made it into clubbed it into one section only, that is 41. But whereas 41 with different clauses, 41.1 is talking about the handwriting, and 41.2 is talking about the opinion as to digital signature when relevant. So these two things are clubbed and only one section is given, but that section also they have included that as a subsection 1-2, subclause rather. So this is one major change also you need to observe. Then as I told you also 57, now it has become 52. So what is 57? I think judicial notice, if I am right. Yes, correct. 57 is, it says facts which need not be proved. So wherever the judiciary or the judge takes notice of certain things, those things need not be proved, isn't it? And what are all the things that the judiciary will take notice of? They have given a number of illustrations here, n number of examples where the judicial notice is taken, and such judicial notice, whenever it is taken on any fact, that fact again need not be proved again. So that's what it says. And the wording, as I said, initially used was must. If you see the very heading of the 57, facts of which court must take judicial notice, that is the wording. Now you see, in place of must they have put shall. So whenever in the act, if you see the wording, in place of must, if they say shall, that means it is mandatory. That means invariably they have to take. It's not option, it is mandatory. That is what we need to observe. Then, and we also said 63 in the old IEA has now become 58 in the new act, and secondary evidence, they have included lot of changes in that, and they have added, if you see, oral admissions 6 and written admission 7, evidence of a person who has examined a document, the original of which consists of numerous accounts or other documents which cannot conveniently be examined in court, and who is skilled and all. So they have included again these subclauses. Now when it comes to again 64, now becoming 59. So we'll move to 64 and see what is the change there. So in 64, they say proof of document by primary evidence. Proof of document by primary evidence is what is given as 64. Now what does it say? Documents must be proved by primary evidence except in the case hereafter mentioned. That means if you want to prove a document, you have to produce the original document itself. There is no way that I'll come and read the contents of it and you please admit. You can't say that. So here the wording again, to give more emphasis that a primary document only will be accepted and all, they are using the word again, the shall word. So in 64 also, in place of must, they are insisting that shall should be used. That means somebody wants to prove a document or prove a fact through a document, then invariably that particular fact in that particular document has to be proved by bringing the document itself and speaking about the document. You have to produce the document invariably. So for that reason they are using the word shall. Then here again there is I told you a new act, a new section 61. Now it is talking about the admissibility. Hitherto we were only banking upon the old version of Evidence Act 65B, and we all know that we are so familiar with so many case laws and all, what is 65B, why a certificate has to be given and all. Now that is but still there were a lot of issues with regard to the admissibility of the electronic or digital records. Now the 61 section, which is now been added as a new section, it very clearly says that admissibility of electronic or a digital record, nothing in the Abhiniyam shall apply to deny the admissibility of an electronic or a digital record in the evidence on the ground that it is an electronic or digital record, and such a record shall have the same legal effect, validity and enforceability as paper record. If you see, 65B is replaced with 59 now. 59, 65B is not there now. In place of 65B you see 59, section 59. So which is talking about the proof of documents by primary evidence. Now what are the other things if you see? Again section 75. What does section 75 talks about? I think the documents, private public documents, if you see, section 75 is also talking about the private documents. So that there is no separate definition for that. Whatever is not a public document, the others are private documents only. That's the only difference. Whereas for public document they have given list of documents which need to be considered as a public document, but other than what is given in as definition under public document, other than that any other thing will be private document. That's the definition that they try to give under the old act. Now what is the new addition? All other documents except the documents referred to in the subsection 1 are private. Subsection 1 ka matlab ka, what is that? Subsection 1, documents forming the acts of records of the acts or the sovereign authority. The sovereign authority, they said, is now in place of that, except that all others are private documents. That's what we need to understand. Then if you see now 82 section, coming to 82. So what is 82 section all about in the old act? That is our Evidence Act. Anybody has the Bear Act with them? No issue, I have the Bear Act before me. I can read it from that because I also wanted others to see simultaneously so that you will understand it better. Now 82 of the old section says presumption as to document admissible in England. See again. So England without proof of seal or signature. See. So whenever it is relating to some colonial this thing wording, so they are doing away with it because they are now obsolete. We are no more under British regime. We are free, independent, democratic countries. So that is the reason why they say that since that is there, we have deleted that particular section. Now presumption as to document admissible in England is no more now. That section is completely deleted. So that is one more thing. Now all 85A, 85B, 85C, there are again subsections under that. So which talk about presumption as to electronic agreements and electronic signatures and then electronic signature certificate. These three. So if you see these three, now they have made them as separate sections because electronic documents or digital documents, they need to be understood in a very detailed manner because now we are into electronic era. Though some documents still exist in the conveyance and all, I mean they are still there in the document form only, but except that most of the transactions either from the consumer side or from the government side, the transactions are in the form of electronics. So in order to have a separate elaborate sections, they have removed the amendment versions 85A, B, C, and they are giving separate sections for that. So starting from if you see 85A, B, C now have become 85, 86, 87. They have become 85, 86 and 87. And electronic now is replaced with electronic or digital. So it can be both. So that is the reason why in that place they have given the word electronic. Wherever they said electronic agreement, electronic record, electronic signature. So wherever the word electronic is appearing, now they are replacing that word with electronic or digital. Electronic or digital, because there can be two formats, so they are including that word. Then again if you see the sections 92, that is the old Evidence Act, the section number is 92 and in the new act it has become 95. So what does 92 say? What is the change in that and what is the heading of that? If you see 92, it says exclusion of evidence of oral agreement. Exclusion of evidence of oral agreement. Now it has become 95. So in that what they are doing is, again the illustrations are, if you see the illustrations, so they are again saying wherever Calcutta, London, these words are there, they are changing that. And one more in the illustration only, so wherever small figures like, for example, one place they have given only 1000. So there, instead of figure, they are putting, adding the word only 1 th ouscnd 1000. In words they are giving. And 1st March they have used words, and then they are giving first Roman number 1st March. And then where there is a figure in one of the illustrations, they are given 500 rupees only. So 500 rupees or maybe 200 rupees. So in an illustration which is called H, A hires lodgings of B and gives B a card on which is written rooms rupees for 200 a month. So they have that figure of 200, now they are making it to 10,000 only. And somewhere, and again in the same example, A hires lodging of B for a year and regularly stamped agreement drawn by an attorney. So wherever attorney, as I have told you, attorney word is now again replaced by advocate. So illustrations only, most of the time you see that whenever these words are appearing, attorney or the queen and all, they are changing the words. That is the thing. Again, going back to 100 and 100 से हमको ये burden of proof आ रहा. From 100 onwards, we see that the heading is, the burden. Who has to prove the burden? On whom is the burden? On whom is the burden to prove? So, of the burden of the burden of proof, that is the heading. Now, 100 is just before that. It says savings of provisions of Indian Succession Act. See, Succession Act of old version is mentioned. Succession Act of 10 of 1865 they are mentioning. Now there is an amendment also, new act in that place has come. So they are referring Indian Succession Act 1925 now. In place of old act of 1865 which has got a mention in old evidence act under 100, now that is been changed to 1925 of Indian Succession Act. So that is one more change you may have to notice. Again under 96, if you see 96 also similarly the wording wherever HIA DRA BAD Hyderabad, that is been given. So they are removing it and then they are giving a separate name. They are giving Ramghar in Rajasthan, Ramghar in Uttarakhand. So they are giving different names. So those names with which now we are familiar, their idea is let us remember those states instead of remembering a very difficult state. It would be better that we remember a easy name. So in the illustrations, instead of those words, they are using Ramghar in Rajasthan and Ramghar in Uttarakhand. They have used these words. Then again 98, if you take 98 section is about evidence as to meanings of illegible characters. Evidence as to the meaning of illegible characters. So that is the heading of 98, and now in the new act it is becoming 101. Provincial is replaced by regional. So provincial was an old fashioned word which we used to use when colonial thing was there. So they are, I think probably in the colonial where it is coming. Yes, in the act itself, in the section itself, if you see, evidence may be given to show the meaning of illegible or not commonly intelligible characters of foreign, obsolete, technical, local and provincial expression. So wherever the word provincial is there, they are using the word regional. They are now replacing provincial word with regional word under old 98, now becoming 101. That is the change you may have to notice. Then again we also discussed about one presumption that is being now replaced with 84. Now one more thing is 113 is also secession territory. So 113 is talking about a presumption proof of cessation of territory. It is talking about proof of cessation of territory. Now that particular thing, 113 is completely deleted. They have deleted that. So it is talking about a notification of the official gazette that any portion of British territory has before the commencement of Part 3 of the Government of India Act. So these are all outdated, old-versioned acts and then old-fashioned words and acts. So they have removed that particular. It's talking about the colonial thing, British India and then Act, Government Act 1935 and also they said there is no point in continuing that section. So they have done away with it. 113 is completely deleted. So now here again 112. If you see 112, which is talking about the legitimacy thing, which is very important. All of us used to remember that section so well and all. Now that section has become as 116 now. 112 of old legitimacy thing is becoming now 116 in the new act. So what is the, again gender neutrality is the strongest point that they are keeping. The legislators are very particular about gender neutrality. Probably that is the reason why in place of son, so the text of the section 112 reads like this: the fact that any person was born during the continuance of a valid marriage between his mother and any man, or within 280 days after its dissolution, the mother remaining unmarried, shall be conclusive proof that he is the legitimate son of that man, unless it can be shown that the parties to the marriage had no access to each other at any time when he could have been begotten. So the wording here is, no, where if you keenly observe, the word son has been used, isn't it? So son is now replaced with child. Son is removed and now that is being replaced by, see, legitimate son of that man. It is written like son. So son, they are not very happy with that word because general neutrality they have to follow. So they are changing the word to child. So that also you have to remember. Now 125. 125 is talking about, I think, privileged communication, if I am right. Let me turn and see. It is talking about, 125 is talking about information as to the commission of an offence. Information as to the commission of the offence is what is written as 125 in the old act, and now that 125 becomes 131 in the new act. Information as to commission of offences. Whence is replaced by when. So there is a word called whence, the second line. So the section reads as, no magistrate or police officer shall be compelled to say whence. So they have used this word whence. So British English maybe whence means. So they are not happy with that, they are putting when there. Whence is, I think, a British old version of when. So because any act has to be, if it has to be implemented, first it has to be understood. So if you use words like this, whence, wheres and all, it will be difficult for anybody to understand. So to make it little simpler, so the word whence is replaced by when again. Then coming to 126, what does 126 tell us? It is a professional communication. Now you see again the words barrister, these things are included, isn't it? So it says, no barrister, attorney, pleader or vakil shall at any time be permitted. So that is the word, vakil, barrister and or attorney, these are the words. So now they said do away with all that and then put a single word called advocate in that. Is replaced with employment. Employment is also another word they have used. So employment is now removed, and in that place of employment, see, employment they have used. This word employment they have used. Now they said employment is not the right word, but you may have to use some other word. So what does it say?
Engage.
One second, let me just see and then tell you the correct word. So employment, they say it should be replaced with service. It's not employment, but it is service. The word employment should be replaced with service. So it says pleader vakil so and so at any time be permitted unless with his client's express consent to disclose any communication made to him in the course and for the purpose of his employment as such barrister. So employment as such barrister is removed, removed that word, and then service they have put, and pleader and all they have again removed. And subsection 1 employment is again replaced by professional service. So again their subsection they are giving again employment. In the subsection 2 proviso 2 they are again mentioning employment. So there also they say it's not employment, it should be made as professional service. So in place of employment, here in the proviso 2 they are saying a professional service, professional service. And again, of course, advocate, attorney has to be replaced by advocate. And coming to 127, 127 is talking about the provision of section 110 still apply to interpreters and the clerks or servants of the barrister, pleader, attorney. Again the same thing it is coming. The servants of barrister, pleader, attorneys and vakils replaced with employees of the advocate. So all these category of interpreters, then the clerk, servant of barrister and all is replaced as they are all employees, isn't it? They are not servants and all. You cannot call them now. The finest word that can be used for them is the employees of the advocate. So they are using, instead of those words, they are using employees of the advocate. And again under 129, if you see confidential communication with legal advisor, so that is the heading in the old Indian Evidence Act. Now it is, if you see, if you read that, it says no one shall be compelled to disclose to the court any confidential communication which has taken place between him and his legal professional advisor. So the word legal professional advisor, now they are replacing it with legal advisor. Legal advisor. So it's no more legal professional advisor, but it is legal advisor. Then again see the example, the section 153. What does 153 talks about? 153, you see, it is talking about the exclusion of evidence to contradict answers to questions testing veracity. Testing veracity. Now in that, one of the illustrations, if you see, again in the illustrations, somewhere they have used the word Lahore again. So they are also not happy with these words, Lahore, Queen and all. So they are again replacing Lahore with Goa. Lahore has been replaced by Goa now. And Calcutta again is replaced now with Varanasi. In that particular illustration they are using these words. Not where every time Calcutta is there, not why we have to take Varanasi. Only in this particular illustration they have used these words. So evidence is offered to show that he was in that on that day in Calcutta. So one of the illustrations it says, and let us see where Lahore is mentioned in which illustration. Here only. Evidence is offered to show that A was on that day in Calcutta. The evidence is admissible not as contradicting A on a fact which affects his credit, but as contradicting the alleged fact that B was seen on the day in question in Lahore. So they are removing these words. Instead of Calcutta they are putting the word as Goa, and in place of Lahore they are putting the word as Varanasi. This is one more illustration only. They are very particular about these things, you know. Again 155, it says it says impeaching the credit of witnesses. One of the primary aim of any cross examination is to impeach the credit of the witness and thereby tell him that he is this since his credibilities are not believable, then you may not have to count on the statement that is given by this man. So you can discredit him and then you can throw away his statement. So for that, impeaching the credit of the witness is very important, and that is being dealt in the Evidence Act under section 155. Now that 155 is becoming 158. Impeaching the credit of the witness is now becoming 158 in the new act. Now there is an illustration that is given for this, and in that illustration B especially, they are mentioning that A is accused, is replaced as, they said A is indicted for the murder of B, isn't it? That is the thing that they have given. So in that illustration, B illustration, they are saying A is accused of the murder of B, and C says that B when dying declared that A had given B the wound of which he died. Evidence is offered to show that on a previous occasion, C said that B when dying did not declare that A had given B the wound of which he died. The evidence is admissible. So that is the illustration that they are giving. And A is indicted of the murder. Instead of that, they are saying A is accused of the murder. A is indicated in that place, they are saying A is accused of. So that is the minor difference that you may please notice. All modifications are happening only in the illustration, not much in the content of the section, except for the number of the section. Everything remains the same. Now 159 is talking about refreshing the memory. 159 in the old act is talking about the refreshing memory, when witness may use a copy of document to refresh memory, isn't it? Now in that, if you see, an expert is the word that has been used, and now that word is now replaced with provided further an expert. Provided further an expert. If you see the wording, they have used that, and then now they want that to be replaced as the provided further an expert. That's the wording they have used now. An expert may refresh his memory by reference to a professional treatise and all. It is talking about all that, but the only change that is there is they said provided further an expert. That's the wording they are using, isn't it? So that is one small thing you may have to notice. I think we have done with Evidence Act, and we have not left any section. Whatever minor, major differences that are there, we have almost done with that. And let us come back to the general thing, MLC, that is medico legal. Then we also will talk about some nuances under fingerprints and all. Now we say that fingerprints are unmutable, immutable, isn't it? That means once they are formed, they are going to remain forever. Even after the body undergoes decomposition and all, only in the very late post-mortem change, otherwise they are very much present. So even dead bodies, if you want to take fingerprints, you can also break the rigor mortis and then go for fingerprints. It's what is we have learned in standard books. Now, is there any disease, can you name any disease where you don't see or completely fingerprints vanishing? Is there any disease which can modify the fingerprints or which may obliterate completely the fingerprints? Disease in a person. Anybody?
Disease is there, ma'am, but I don't remember right now. There is some disease in which it can be.
This is leprosy है ना? लेप्रेसी वो उंगलियां पूरा फेस पूरा डिस्फिगर हो जाता है ना, उसमें स्किन पूरा चल जाता है, and then person becomes become disfigured and all, the facial features and all lost. The skin also loses its texture. So that is called leprosy, and it is contagious disease, leprosy. And under leprosy also there are categories of leprosy, but lepromatous leprosy is the one which will completely modify the fingerprints. Spelling is Lepromatous. Lepromatous leprosy. That kind of leprosy will erode completely the fingerprints. That is what you need to understand. Now, can you just tell me what is the most common type of fingerprint pattern in India? Is it arches or loops or whorls or what is it? Very common.
Loop.
What pattern or what did you say?
Loop.
You said loop. Loop is correct answer. Now, correct only. Loop is correct. Then, if suppose you wanted the doctor conducting the postmortem to collect viscera because you are suspecting a case of some poison and all, in that case, what is the best preservative that can be used for a viscera? So I am not restricting myself only to fingerprints. Miscellaneous we will talk about. So what is the best preservative and cheapest?
Activated alcohol.
Then viscera. Viscera, I hope you understand the word viscera.
Yeah. Internal parts, there is saline.
Yes. Saturated solution of common salt is called saline. Saturated solution. That means saturation means complete concentration. If you add some more, it will precipitate. It will not dissolve. That is called the saturation. Saturated solution of common salt is NaCl. So that is otherwise called as saline. SALINE, saline. So you should not say only salt. You should say saturated solution of common salt. So common salt is sodium chloride. So saturated solution of sodium chloride is otherwise called as saline, and this is the preservative. And somebody said alcohol. Suppose I am suspecting alcohol poison. In that case, I cannot use alcohol as a preservative, isn't it? So the best way is only where alcohol is prohibited, like states like Gujarat where it is completely prohibited. So doctor cannot ask for alcohol and preserve as a preservative. Even for any purpose also it is prohibited. So the best, even alcohol is a little costlier, you can't use that as a preservative unless the situation warrants, otherwise you can't use. The best thing is only this saturated solution of common salt. Then suppose your aim is to, where you do not know the identity of the person, you want to establish the identity of the person through DNA fingerprinting. Now you have only viscera. You are asking the doctor to conduct the postmortem, and then you are also suspecting some poisoning also, and you do not know the identity of the person. In that case, you will ask the expert from FSL to do the DNA fingerprinting also, isn't it? In that case, what is the right preservative? Normally, the dead tissue will be preserved in which solution? Dead tissue? Any idea? Normally formaldehyde and all they use in hospitals and all. This is the solution to be used. But then never use never suggest the doctor conducting the postmortem to preserve the viscera or any body part in formaldehyde when your intention is to establish the identity of the person through DNA fingerprinting. DNA fingerprinting, this formaldehyde is going to interfere to a very great extent. So avoid preserving the viscera in formaldehyde when your aim is to establish the identity of the person through DNA fingerprinting. So this point is very valid point, and most of the time it has been asked in the interviews. So remember that. So formaldehyde normally for any other tissue, if you want to preserve, for example, you want to preserve a fetus. So ठीक है, but as long when your intention is to establish the identity, then don't use formaldehyde. You may have to use even common salt is good enough. If you want to use common salt, you can use that. Then, so there is what is known as vitreous humor. Where is it present? Vitreous humor?
Eyes में, आँखों में.
आँखों में. So after death, you see a particular metal in a very high concentration in the vitreous humor. What is that metal?
Potassium.
Yes, it is potassium. Now we have heard post-mortem cooling, isn't it? There is a word called post-mortem cooling, isn't it? As the body approaches the atmospheric temperature, and once it attains, there is a gradual reduction in the body temperature, isn't it? But then there is a contrast word which we use, post-mortem caloricity. What does that mean? What is post-mortem caloricity? caloricity. Any idea?
कंफ्यूजन थोड़ा थोड़ा है पर कंफ्यूजन.
ठीक है, नहीं कंफ्यूजन क्लियर करने के लिए हम हाजिर है इधर, नो प्रॉब्लम. सो पीएम कैलोरिसिटी इज ऑपोजिट योर पीएम कूलिंग, है ना. इसमें यू सी दैट देर इज ए रेज इन टेम्परेचर, दो बॉडी इज द पर्सन इज डेड एंड गॉन, इट हैज बिकम अ डेड बॉडी, बट स्टिल यू सी देर इज a raise in temperature. So what is that raise in temperature? Why is it due to? It is because of some infections, some disease and all, especially rabies, in disease like rabies and meningitis and then nephrotitis. Nephrotitis means a disease relating to kidney and all. And meningitis means disease affecting the brain and all, brain membranes and all. So some poisoning cases like alcohol, strychnine poison. So these are some typical cases where you see instead of PM cooling, you see a raise in temperature of the dead body. This is called PM caloricity. PM caloricity is opposite to PM cooling, and it happens in some disease like nephritis, meningitis. Then you also see that in some poisons also, alcohol, strychnine, these kind of poisoning also, you see that there is a little raise in the body temperature. So that is called, that phenomena is called PM caloricity, caloricity. And we have discussed cadaveric spasm, adipocere and mummification, all that we have discussed in the last class only. Now coming to whenever we want to establish the time since death, then we also depend upon what is known as stomach emptying time also. So what is the rough stomach emptying time? Suppose how many hours you can say? About how many hours of death you see the last meal, since last meal?
8 hours.
No, 1 hour. 1 hour, about 1 hour since the last meal. You will see the stomach emptying. Stomach empties and then it goes to again intestine and all, that stomach emptying will happen within 1 hour of the meal. Now food items like dal, for example, somebody has consumed and in the post-mortem you find dal being present, you have identified in the stomach. Then what can you say about that? How many hours must have lapsed after eating the dal? How many hours you can say? In the post-mortem you are able to see food particles, food pertaining to dal and all. So it says 4 hours. Now it says 4 hours. In the post-mortem if you find, it is 4 hours. That means person died within 4 hours of consumption of that particular last meal. That is what is you need to understand. Now if I can say, what is the surest sign of ante-mortem hanging? So we know that there are asphyxial deaths, hanging, then strangulation, smothering, all that we know. Now if I say I have to confirm a particular asphyxial death as ante-mortem hanging, that means person died on account of hanging. That is what we mean by ante-mortem hanging, isn't it? Now if I have to say that this is a surest case of ante-mortem drowning, by looking at what symptoms will I be able to say this?
ड्राउनिंग का ना,
ड्राउनिंग का नहीं, हैंगिंग का.
Hanging, tongue protruding.
Tongue protrusion can also happen in others also. I am talking about hanging in particular.
Fracture of thighs bone.
No.
fired one.
No, no, listen to the question. Ante-mortem hanging, I am saying. Surest sign of ante-mortem hanging. Dribbling of saliva, because dribbling of saliva happens only when the person is alive, isn't it? While he is struggling for his life and all, there is dribbling of saliva. So that cannot be mimicked, and it will not be seen in other kinds of asphyxial deaths. So this is the surest kind of hanging, ante-mortem hanging, isn't it? Dribbling of saliva. So on the corner of the mouth you see saliva oozing out. So that's a clear, surest 100% sign of ante-mortem hanging. Any doubt in that? Dribbling of saliva.
No, madam.
But you will not see that. The most prominent thing in strangulation is you see bulging of eyes, and then you also see a lot of petechial hemorrhage coming out and all. That is more prominent. And in drowning, what is the most prominent and most surest sign? Yesterday we have discussed this.
Diatoms.
Diatom ठीक है, but another very prominent diatom and all FSL people will tell. So for us as investigating officer, what is the external thing that is most visible and most prominent and most sure? हैंगिंग तो ठीक है, सलाइवा तो हो गया ना, हैंगिंग के अलावा उसमें सलाइवा तो नहीं आएगा ना. खाली हैंगिंग में एस्फिक्सियल टाइप ऑफ डेथ हैंगिंग में ये आएगा, ड्रिबलिंग ऑफ सलाइवा आएगा, बाकी में नहीं आएगा. दैट इज द रीजन वाई वी सेड हैंगिंग ओनली, इट इज सलाइवा इज सेम. ड्राउनिंग में कल डिस्कस करें, आपको याद आना चाहिए. व्हेन आई सेड वो स्नेक का उसमें भी आता, आर्गनोफॉस्फोरस में भी आता, इसमें भी आता, हाउ टू डिस्टिंग्विश, तब बात करें हम. क्लू भी दे रहे, हिंट भी दे रहे आपको.
Frothing.
हाँ, करेक्ट. Froth in case of drowning is typical. Why is it typical? So it is leathery somewhat, it is very fine, and even if you try to remove that froth with the help of a cotton and all, and then you once again press the chest, ऐसा एक दबाए तो फिर आता, froth आते रहता. And how will you distinguish that from the organophosphorus? Organophosphorus का मुंह में वो थोड़ा स्मेल आता, बोले हम, कौन सा स्मेल आएगा? डॉक्टर कंडक्टिंग को, हाँ,
गार्लिक टाइप
नहीं, नहीं, वो तो पॉइजनिंग का, अलग पॉइजनिंग है.
केरोसिन.
हाँ, करेक्ट. केरोसिन में क्या है? वाई केरोसिन? आई टोल्ड यू द रीजन ऑल्सो वाई केरोसिन. ऑर्गेनोफॉस्फोरस, they are organic material, so they will be soluble only in organic. Kerosene is also organic, made of carbon and all, so that is called carbon organic, isn't it? So kerosene, in order to make them miscible, they will not be miscible with water, so they use kerosene. They can use others also, ether and all that, they are all costly, kerosene is the cheapest. So what they try to do, the farmers and rights, what they do is they try to dissolve the insecticides and fungicides in the kerosene, and then they try to spray that on the fields. Now if he is frustrated, he wants to end his life, as a method of suicide he consumes that. So whenever this organophosphorus pesticides are being consumed, there is a typical smell. So the doctor conducting the postmortem, before he opens up the body and all, he will look for some external examination. People are under the misconception that postmortem includes only cutting of the body. It is exactly not that. So before opening up the body, the doctor conducting the postmortem also looks for some external manifestations. Like one is looking at the color of the PM stain, whether the pupils are constricted or dilated, or whether there is some kind of a wound or not. I mean, these things, external things, he looks for initially. So once these are there, and smell, what kind of smell is emanating from the mouth and all, he looks for this. And whenever he suspects smell of kerosene, he will probably suggest the FSL people that please look for this kind of phosphate kind of compounds, because the time of FSL people is also precious, isn't it? If the doctor conducting the postmortem doesn't give any clue, probably the poor scientist has to work 24 hours and then look for all possible poisons which are available in the market, just to reduce his burden. Now the postmortem, it's not that blindly we go by what postmortem doctor says, but then it will be a kind of a clue for us also. So instead of focusing on all permutations and combinations, what we can try is, initially try, because he is indicating a clue that there is a smell from the mouth of the deceased. So our first choice will be, we try for the organophosphorus, and as said by the PM doctor, if सचमुच हमको भी positive आ रहा, we'll go by the word of the doctor. So for that purpose it will help immensely. So this is kerosene smell is an indication that most probable poison that might have been used for killing the person or self-killing is organophosphorus compounds, which is the chief thing in any insecticide, insecticide poison. Now, you have heard about the word cave coronary.
Yes.
What is it?
कंफ्यूजन है बट
बोलिए बोलिए, कोई प्रॉब्लम नहीं.
एयरवेज में कुछ अटक जाना जैसे मीट वगैरह जो
हाँ
वो है.
हाँ वही है. सो ए स्मॉल बोलस ऑफ फूड. अब जल्दबाजी में मत खाओ बोलते हैं ना, इसीलिए बात करते मत खाओ बोलते हैं ना लोग, बुजुर्ग हमारा बोलते हैं ना. सो खाने के टाइम पे कोई टीवी नहीं देखना, कोई किसी से बात नहीं करना, वो सब बोलते हैं ना. दैट इज द रीजन, दैट इज द रीजन. नाउ if you just, there is an epiglottis kind of a thing, and if you keep talking, so that acts as a lid for our windpipe, and if you keep talking and if you are elsewhere, if your brain is elsewhere, what will happen while swallowing? That bolus, instead of going into the food pipe, it goes into the windpipe, isn't it? So in order to avoid that kind of a thing, people say, keep telling us, don't you concentrate on what you are eating, don't talk too much and all. I mean, these are the things they tell. So what happens in this particular kind of phenomena is, a small bolus of the food or fish bones. I mean, normally people, they try to remove all the the what are they called, fish में आता ना, बोन में fish bone खाते, वो spines को, हाँ वो आता ना. So because I am not a non-veg eater, probably I do not know. My knowledge is from the books only. So ये fish का bone खाए जब भी उसमें thorns will be there, spine kind of a thing will be there. So वो respiratory pipe में passage में अटक जाता है. So उससे क्या होता है? I mean, mostly if a heavy drunkard is there, so he will, why this name cave coronary has come means, so when he goes to a cave, अचानक उनको क्या होता है, ऐसे drunkard अचानक इनको मर जाता है. So people will think that he is dying of heart attack. Now it is not the case. He is not dying of heart attack, but then he is dying on account of asphyxial death, because his windpipe is choked. His windpipe is choked because he is heavily drunk, and then top of it he is trying to engulf food. जल्दबाजी में swallow कर रहे, वो swallowing करने में क्या हो रहा है, इनको windpipe में चले जा रहा, जो भी खाना खा रहे, instead of going that food going into the food pipe, it is going into the respiratory pipe. So अचानक मर जा रहा. So people think अचानक मर जाना बोले तो what comes to our mind, ये तो cardiac arrest ही होगा. बट सचमुच उसमें केफ में बैठ के हम लोग आराम से जल्दबाजी में खा रहे पूरा खाना, सो केफ में मर जा रहा बेचारा. तो उसका नेम ऐसा ही केफ करोनरी आया है. तो फ्रॉम दैट द वर्ड केफ करोनरी हैज कम. I think now there is no confusion, little confusion or more confusion. I think it's not there with you now, शैलेंद्र जी. तो ये तो सचमुच आप जो बताया वही सही है, बट so you would be more confident in telling that you know that. You know most of it, but you should also be confident, है ना. Then ये जुडिशियल हैंगिंग में क्या होता है, मौत इतना आसान क्यों बनता है, जल्दी हो जाता है, इमीडिएटली क्यों हो जाता है, व्हाट इज द थिंग, एंड व्हाट हैपेंस व्हेन यू फॉल फ्रॉम ए हाइट. ऑलमोस्ट सिमिलर होता है दोनों में, मगर फॉल फ्रॉम ए हाइट थोड़ा हमको, एटलीस्ट people who fall from heights, they would have died before reaching the floor. Out of heart failure they must have died even before reaching the floor. वो तो अलग बात है, मगर तो what is that, जुडिशियल हैंगिंग में क्या होता है. cause of death क्या हो सकता है? हाँ,
suspension of body, they are raising that.
no, कौन सा organ in the body you think will be affected for immediate and इतना दर्द भी नहीं होता ना, पेन भी नहीं होता ना, what is that? Anyway, I will give the answer for that. It is the spinal cord laceration. So spinal cord, you know, that is the pivotal thing. That is the fundamental thing. From that, your nerves and all of them, they will emanate. When that itself is getting lacerated, then where is the question? So in judicial hanging, the instant death is an account of spinal cord laceration. Spinal cord laceration. I hope you know the word laceration. So spinal cord laceration होता है in all judicial hangings. And what happens to a height, a fall from a height? इसमें laceration नहीं होता है, tearing होता है, spinal cord का tearing होता है, and hemorrhage भी होता है इसमें, and lot of blood also will come out. I mean, you will have a little pain, even if after touching the floor also, if somebody is still alive, he will have a very severe pain and all, you know. Then, so drowning also is one kind of asphyxial death, we know that. Now there are 2-3 types of again drowning, if you can tell me what they are.
Dry drowning, wet drowning.
Wet drowning. तो ड्राई ड्राउनिंग बोल के क्यों बोलता है इसको? Why we call it as a dry drowning?
Water will not go to lungs.
हाँ, वो तो सही है, but then why death happens? If water is not going, lungs will not be swollen, no, nothing will happen, then why still death happens? In dry drowning, what is the reason why people die of dry drowning? What is the reason? I'll tell you again. When a person falls in cold water, what will happen? All of us, we have skin, and skin has got lot of receptors, isn't it? There are receptors. Now suddenly if you jump into cold water, what will happen? The skin receptors, they become all of a sudden activated. And immediately what will happen as a result of this, there is a vagal nerve, and that gets inhibited. So what is the repercussion of that? When vagal inhibition happens, you see that heart also suddenly stops. So that is the reason why, though there is no water entering into the body in cold water, now you see that death is an account of heart stoppage, and that is activated. Why a heart suddenly stops in? Because of vagal inhibition. So dry drowning is equal to vagal inhibition is equal to cardiac arrest. I hope I am clear.
यही है क्या?
हाँ,
हाइड्रोक्यूशन भी बोलते हैं.
हाँ बोलते शायद, ये वजह ये है, whatever name that is given, but the reason is this, though water is not entering, because we are calling it as a dry drowning, we are understanding that there is no water, but still why people die. So that is the reason we may get. So इसीलिए आप शायद जो elders जो बोलते हैं उसका सुनना है. So when you are coming from a hot sun and all, don't drink cold water बोलते. कभी सुना है लोग ये बोले जब?
Yes.
हाँ, why they say?
ये भी बोलते हैं कि
हाँ,
ठंडे पानी से नहा रहे तो एकदम से सिर पे पानी मत डालो.
हाँ.
थोड़ा सा पैर.
So these are all the reasons. उसमें क्या होता है? Whenever cold water comes in contact with skin, the skin has got lot of some. This is the first initial protective layer है ना हमारा. वो बर्निंग में वार्ड में गए तो बर्निंग से ज्यादा लोग नहीं मरेंगे. बर्निंग के बाद जो इन्फेक्शन जो होता है ना, क्यों बोले तो बर्निंग में पूरा जलन होता है ना, स्किन का पूरा जल जाता. उसमें क्या है, तुम्हारा डर्मिस जो है अंडरनीथ स्किन जो है टिश्यूज, वो तो एक्सपोज हो जाता है, बैक्टीरिया तो आ जाता है उसके ऊपर, बिकॉज देयर इज नो प्रोटेक्टिव स्किन ओवर देयर. सो इससे ज़्यादा सेप्टिसीमिया हो जाएगा, फर्दर सेकेंडरी इन्फेक्शन हो जाएगा, उसी के वास्ते वो लोग मर जाएंगे ना. सेप्टिसीमिया डेवलप हो जाएगा अंदर पूरा, तो इसी के लिए लोग मर जाएंगे सेकेंडरी इन्फेक्शन से. सो इसीलिए ये क्या है, स्किन जो बहुत नाजुक होता है, सो स्किन का रिसेप्टर जो होता है दे बिकम वेरी एक्टिव वेन एवर कोल्ड वाटर कम्स इन कॉन्टैक्ट, ये तो एक्टिव हो जाएंगे ना। क्यों बोलो तो हमारा शरीर का भी वो है ना, एडजस्टेबिलिटी अडेप्टेबिलिटी है ना, तो एकदम इसको हीट पहुंचाने के लिए क्या करेंगे, वो रिसेप्टर्स को एकदम एक्टिवेट करेंगे। और उस मामले में क्या होगा, एकदम ये इमीडिएट एक्टिवेशन से क्या होगा, ये वैगल नर्व बोल के एक वैगल नर्व होता, so that is connected with heart and all, you see that vagal nerve gets inhibition, it gets inhibited. Now that inhibition is followed by heart stopping. So that is how you see that whenever cold water, when somebody falls into that, so due to vagal inhibition, though it is we can say it's a misnomer, we shouldn't say that it is dry drowning, but then we are familiar with that word dry drowning, we can still use that. So that is because of vagal inhibition. That's what you need to understand. Then this point we have discussed, a fine white leathery tenacious froth is seen at the mouth and nostrils in the case of drowning. It increases on compression of the chest. This I have already discussed. So how to distinguish a case of snake bite from that of even carbon, even organophosphorus also you see some kind of froth, but then that is not that finer when compared to the froth that comes out of drowning is much more finer and much more copious. Copious माने large quantity होता है, and after removing also अब chest को दबाए तो फिर आ जाएगा वो वैसा ही froth. So that's a very clear 100% sign of ड्राउनिंग. वो ड्राउनिंग कैसा हुआ, सुइसाइड है, होमिसाइड, वो तो हम तो इन्वेस्टिगेशन में ही हमको पता चलेगा, मगर हम तो ये तो बोल सकते हैं दैट पर्सन डाइड ड्राउन्ड इन वाटर, उतना तो बोल सकते हैं. नाउ and detection of diatoms also, not in detection of diatoms in the bone marrow, you have to be very very specific. The examiner वही पूछेगा, वो diatoms तो हर जगह है, आपका पानी पीने का पानी में भी है, जो पानी नहाते उसमें भी रहता, then how can you say that presence of diatoms is an indication? वो तो पूछेगा ना, तो what will be the answer then? हाँ, only when you find diatoms in the bone marrow of a diseased body, you can say that the person died on account of drowning. पानी में डूब के मर गया, उतना तो बोल सकते. And then death is only on account of drowning. That means there can be death elsewhere. The person might have been died elsewhere, and passive body भी उसमें पानी में डाल सकते ना. But how to say that death is only on account of drowning? That means वो पानी में डूबे समय में वो जिंदा था, जिंदा आदमी पानी में डूब के मर गया, वैसा तो बोल सकते, उतना तो बोल सकते. डाइटम्स अगर हमको मिले तो वो उसमें बोन्स में, लॉन्ग बोन मैरो में मिले तो उतना तो बोल सकते. व्हाट इज द रीजन आउट? एनी आंसर? You can try out. It may be a wrong answer. We are not facing any event right now.
क्वेश्चन क्लियर नहीं हुआ.
नहीं, ये diatoms, presence of diatoms, we say that in the bone marrow is a clear indication that somebody died on account of drowning. उतना तो बता सकते. Now diatoms, my question is, diatoms are present everywhere. Even पानी जो हम पीते उसमें भी रहता है. So how they reach up to this bone marrow?
Through lungs.
हाँ.
Through lungs.
Through lungs, correct. See, when you drink water, that will go only through your alimentary canal. It cannot reach bone marrow, है ना? Bone marrow कब reach करेगे वो? When you take water from nostrils. You take water intake from nostrils, your nose, isn't it? So normally while you drink, you don't drink with nose, you drink with mouth, isn't it? But when a person is in waters and जिंदा है, water में रहे जब जिंदा है, what will happen? ही हैज टू इन्वाइट, एंड तैरना नहीं आता इनको, सो क्या करेगा, जो भी है मुंह से भी पानी लेंगे, नोज से भी पानी लेंगे ना, वो तो पानी लेंगे, सो पानी विल ट्रैवल टू द पाथ ऑफ योर रेस्पिरेटरी सिस्टम, रेस्पिरेटरी ट्रैक्ट, isn't it? रेस्पिरेटरी ट्रैक्ट में लिए तो कहाँ तक जाता, वो लंग तक जाता ना। लंग कब तक, ये तो बेलून है, एकदम इलास्टिक है, बेलून जैसा है लंग भी, सो कितना तक बर्दाश्त करेंगे वो प्रेशर, जितना इनका इलास्टिसिटी कैपेसिटी है, जितना तक इसका इलास्टिसिटी परमिट करता है उतना तक तो एक्सपेंड होगा लंग, उसके बाद भी पानी जा रहा नॉस्ट्रिल से, तब क्या होगा, ये लंग के ऊपर जो फाइन कैपिलरीज जो रहता वो बर्स्ट हो जाता ना, सो इट कैनॉट बेयर द प्रेशर बियॉन्ड ए लिमिट। उसके बाद क्या होगा, वो कैपिलरी जो सराउंडिंग है लंग के ऊपर आजू बाजू सरफेस में, वो तो फट जाएगा, उसमें से वो तो खून तो निकलेगा, सो खून से ये जो डायटम से एंटर हो रहा पानी, वो पानी के अंदर अंदर ये भी डायटम्स भी जा रहा, एंड जो खून जो निकला उससे लंग से, उससे जा रहा किधर तक, हमारे बोन तक जा रहा, सो बोन मैरो कट करे तो डायटम्स भी मिलेगा। उसका मतलब क्या है, when he reached water bodies he was very much alive and his death is only on account of drowning, इतना तो बोल सकते। this is what is the explanation that can be given. Am I clear or I am not still clear? What is it?
क्लियर।
हाँ
मैडम
हाँ
एक्सक्यूज
हाँ,
मैम, ब्लड में भी तो मिल सकता है डाइटम,
ब्लड में तो नहीं मिलता ना, ब्लड में तो नहीं मिलेगा।
ऐसा भी पता है कि उसमें जैसा वो ब्लड में मिक्स होके फिर बोन मैरो में जाएगा, तो ब्लड में मिक्स होके ही जाएगा ना।
नहीं, ब्लड में कब जाएगा, आदमी जिंदा रहे जब तो जाएगा, मर गया। नाउ व्हाट यू हैव टू डिस्टिंग्विश इज वेदर समबडी किल्ड हिम एंड थ्रोन द बॉडी इन वाटर्स, है ना, तब भी वो एक्सटर्नल ऑरिफिस से जा सकते हैं, मगर बोन मैरो तक तो नहीं जाता ना, बिकॉज देयर इज नो रेस्पिरेशन। डेड बॉडी में रेस्पिरेशन कहाँ से आता, नहीं रहता ना, सो यू कैन डिस्टिंग्विश।
जैसा अब कोई अभी पानी में गिर गया है, वो डूब रहा है उसमें,
हाँ
तो वो जो डाइटम से उसके नोज से जाएगा उसके अंदर,
हाँ
तो लंग्स पूरा फिलअप होने के बाद,
हाँ,
तो तब तक वो ब्लड में जाएगा ना फिर बाद में।
वो तो है ब्लड में जाएगा, इसीलिए ब्लड में जाके उधर तक जा रहा, किधर, हमारा बोन मैरो तक जा रहा। अगर आदमी मर गया समझो, मुर्दा मुर्दा बॉडी को पानी में डाले ताकि इनका इनका जो भी नहीं पकड़ना, बोल के कोई इसको नहीं पकड़ना, पानी में डूब के मर गया जैसा समझना लोग, मगर इन्हों क्या कर रहे अक्यूज, इनको चाकू से मार के, नहीं तो किसी पत्थर से मार के वो डेड बॉडी को एकदम पानी में डाल रहा। हाउ टू डिस्टिंग्विश, दैट्स व्हाट आई एम ट्राइंग टू डिस्कस। अगर ये मुर्दा बॉडी को डाले पानी में, तब तो ये रेस्पिरेशन नहीं होगा ना, नहीं नहीं है ना, रेस्पिरेशन नहीं है ना इनमें, सवाल ही नहीं है, रेस्पिरेशन का नासिल से जाने का सवाल ही नहीं है, उसमें तो कैसे तो भी नहीं निकलता डायटम।
गजानन साहब का पूछना ये था कि बोन मेरो चेकिंग की क्या जरूरत है, वो ब्लड चेकिंग में क्यों नहीं मिलता, ये इनका कहने का मतलब, बोन मेरो तक जाने की क्या जरूरत है, ब्लड चेकिंग, ब्लड इन्वेस्टिगेशन में क्यों नहीं मिल जाएगा डाइटम, उसको क्यों नहीं मानेंगे, ये उनका कहना है।
ब्लड में रहता है, ब्लड में अब नहीं टिकता ना, दे विल गो टू बोन मैरो, दे विल नॉट रिमेन, ब्लड तो एकदम तो जिंदा है तो उधर ही नहीं टिकता ना, इट विल गो टू बोन मैरो ओनली, they will go to bone marrow, they will not remain in blood, because blood vessel तो ऐसे तो इंटैक्ट नहीं है ना, वो तो फट गया ना, तभी जा सकते ना, वो ब्लड वेसल फट गया इसीलिए वो ब्लड उसमें इंटैक्ट नहीं मिलेगा आपको, उसमें समझ में आ रहा। बाकी ब्लड वेसल्स में नहीं रहेगा, जो ब्लड वेसल्स आजू बाजू हमारे लंग के आजू बाजू है उसी में जाएगा, एंड वो तो फट गया, अब तो आप ब्लड निकालना बोले तो ब्लड नहीं आएगा, आपको नहीं मिलेगा, क्यों बोले तो वो पूरा वेसल फट गया, अब जो भी मिलना है बोन मैरो ही मिलेगा, क्यों बोले तो बोन मैरो तक वो डायटम्स पहुंचता, इसीलिए।
ओके मैम।
गजानन जी, am I clear about that or still some doubt is lingering again?
नहीं मैम, क्लियर हो गया।
हाँ. Then, now, what is hyperpyrexia? What do you mean by the word hyperpyrexia?
नहीं मालूम, नोट किया।
हीट स्ट्रोक। अगर सन में जाओगे और स्वेटिंग नहीं आएगा, इतना सन में आप खड़े रहे ताकि वो हीट स्ट्रोक आ जाएगा आपको। हीट स्ट्रोक इज अदरवाइज कॉल्ड, हाइपर माने ज्यादा है ना, हाइपो माने कम। हाइपर पायर, पायर मीन्स हीट, पायरेक्सिया, पायरो, PYRO का मतलब हीट। हाइपर पायरेक्सिया मीन्स heat, overheat, heat stroke, that is called heat stroke. So heat stroke में there will not be sweating and all. Sweating will be, absence is a clear sign of heat stroke. That is otherwise called as hyperpyrexia. I think that's all for today. We have discussed so many things and एक ही बार हम पूरा बोले तो आपका सर के ऊपर जाएगा. So I don't want your brain to be taxed so much. So अभी बहुत दिन है हमारा आगे जाने का. So probably tomorrow day after